Corporate Law Lab. I'm Neil Taylor, Director of the Corporate Law Center at the University of Cincinnati College of Law. And today by Larry Church, who is at Church Langdon Lopp Banet Law, which we will call CLLB going forward after I fumbled my way through that. We're also joined by Annabelle Fisher, one of our corporate law fellows who is a 3L, who will be a litigation associate at Dinsmore next year. So, Larry, welcome.
Thank you, Neil. It's good to see you. It's been a few years since we've seen each other. And Annabelle, just to let you know, I was in the Dinsmore office in Louisville 2 days last week mediating. So I know many of your soon to be associates and partners and obviously think quite highly of your firm.
So, as you noted, we graduated together. I discovered from running into one of our other friends that we're remembered as having been in the same section, which they now, for some reason, call cohorts. So we spent a lot of time together, our 1L year for sure, and pretty much all the way through. You went to Kent State undergrad, right?
I did. I'm originally from a small town in southern Ohio. And the reason I stayed within state is my father had passed when I was young. My mom was older and had some health problems. So I was the youngest child. And so I always felt that I had kind of the duty and the obligation to stay within at least driving distance in case anything happened. So that's how I ended up at Kent, was because it was only 3.5 hours away.
And you majored in English because
I majored in English because, that's always one of those, how do we say it nicely, ambiguous majors that allows you to do many different things when you move forward. Again, coming from such a small town, I laugh and tell people all the time, I was born up a holla in between two hills. And that's kind of the best way to describe where I'm from. And so went to a very small high school, 50 people in my graduating class. So the concept of actually getting prepared to go away to university was quite a big step, for someone like me. English was the motivating factor because I had a great English teacher in high school. She gave me wonderful motivation, kind of showed me that there was a world behind our little town that I grew up in. And then also, I had the interest because of her potentially becoming a teacher. And so probably goal one when I went to Kent was to go into education. I minored in things that won't surprise you at all. I minored in telecommunications because clearly I needed to be on TV. And then second, in theater because clearly I needed to be on the stage. And so those were easy majors and minors to kind of coalesce together to get we'll call it a liberal education.
yeah, well, I was a poli-sci major because I wanted to make sure that my choice is to either you go to law school or you spend your life in sales.
With great options, and
I
very similar.
spent 2 years in sales and figured out that wasn't the right way. How did you decide to go to law school and why Cincinnati?
Sure. We'll start with the Y Cincinnati. Again, that is very similar to the Y Kent State. I was now an hour and a half away from home. And so it was a simple transition. Cincinnati was a city I knew well by constantly going to Reds games. I had family in Cincinnati. And so, again, that was an easy transition for me. Law school was something I had literally given absolutely no thought to prior to going to college. I'm not sure I had even met a lawyer before I went to college. Some of my friends from college will say that they went away one weekend and came back and I was taking the LSAT. I think it's a little more complicated than that. I had a couple great con law classes as extracurriculars in college, and I think that stimulated an interest. Let me go see what this is about. Had no idea what being a lawyer was going to be about, but I loved education and I loved learning. And so it seemed like a logical next step for me.
What stood out from law school other than the opportunity to hang out with me
Well, you were the dream.
yeah.
Absolutely. If I would have known that, when I was growing up that I had a chance to hang out with Neil Taylor, I would have just gone straight there and skipped everything else. Law school for me, again, was just culture shock. Again, coming from a small town, coming from the small high school, getting thrown concepts that I had never even thought about before stepping in. What I found fascinating about it, though, was the logic part of it. There is a logical way to work yourself through every potential problem and every potential question that you might encounter in the law. And so very early on, I found out that preparation, study, and being ready to go and being fast on your feet was a skill that I actually had. It was something that I could do. So, it's interesting when we were there, I'm assuming it's very different now in 2025 from when it was in 1991. But, the way UC was structured, as you were mentioning earlier, with the sections or the cohorts or whatever you call them now, gave you the chance to kind of bond with a smaller group of people. And I think for those of us who came in not having um, a great knowledge of the law or great plans as to what we were going to do as lawyers, it kind of gave us that little group to not only bounce ideas off of each other, but to give support to each other. So that was very different for me from college, and it was very valuable.
I actually remember sitting at lunch with you, maybe it was Lynn Miller. We were like 6 weeks in, and I remember we were talking about how this is all very interesting, but I wonder when they're gonna teach us the law.
That's exactly right. This stuff is fascinating, but I'm not sure how I'm ever going to use it.
Yeah, and I'm like and they never did.
No, never did. But it's funny when when I talk to people now, I'm always kind of walking them through that. I said, "Oh, it's going to seem like you are just dancing in another world, for at least a year, if not throughout the entire time. But there are skills that you're going to learn there, and there are abilities that you're going to further that actually will help you once you get out. It's impossible to know while you're there, but actually does work."
Yeah, and my idea that I love memorization, or at least I used to, before I have a 6 at the beginning of my age. But, I had the idea that we were gonna be memorizing large reams of data, and because we never did, I'm like, "Oh, this is a different thing entirely than what I thought we were gonna be doing."
Well, I was always fascinated by the fact that there were extremely smart people around us, but there were a lot of those extremely smart people who didn't understand what we were doing. They would try to memorize every fact of every case and then had a complete inability to be able to apply, what they had learned in those cases to a fact scenario or to the real world. I mean, I learned kind of quickly, okay, get the basics. Get the basics from what you're supposed to be learning and then figure it out. Back to that logic part of the puzzle. Because God knows I was by no means the smartest person, probably not the smartest person in my room, even though I'm the only person in here at the present time. But I'm really good at solving problems, and I'm really good at making A and B equal C. And I think once I figured that out in law school, then law school was much easier for me than I was afraid it was going to be.
So then we could talk about law school for another hour, and there would be 24 people that we could find from our section that might find it interesting. But when you graduated, we graduated into a recession, which I remember I was one of the few that had a job just because I'd gone to Arizona for the summer before third year. But there were a lot of people in class that didn't have jobs. And it was, as you said, there was a group of very smart and talented people leading into is that how you ended up going to being a public defender, or was it unrelated entirely to the crappy
Completely
economy?
unrelated. I mean, you know my personality much better than any of the people who are listening. I would say it probably hasn't changed a lot since 1991. I'm not a great firm guy, especially not a great big firm guy. I kind of had figured out during law school that I was a trial lawyer. I love doing moot court. I love doing trial practice. I think I was pretty darn good at it. And so I was like, all right, I need to hone this skill because if I can hone this skill, it's going to translate to whatever I decide I want to be when I grow up. And so I had the opportunity, because I clerked in firms during law school and it was great and had offers from them. It was great. But, it was going to be one of the situations where I was going to be sitting in a library for a couple of years. And that's not my skill. That's not my gift. My gift is getting up and as shocking as it is right now, running my mouth and trying to help people again solve problems. And so the PD's office, especially DPA in Kentucky, seemed like an awesome opportunity. It also gave me the chance to go back into the small town world. You know, as much as I love living in Cincinnati, it's still a big city for me. And so I am more comfortable in the smaller towns, smaller counties, where getting to know people and those relationships were as important as what you actually did on a day to day basis. And it was probably the best decision I ever made. I look back on it now and think by November of 1991, which is when we would have gotten our bar results, I was at a training center called Fawbush in Southern Kentucky, learning from people like Jerry Spence, getting videotaped, giving arguments, really honing into the skills that I feel probably no one else in our class was developing at that time. And those skills and the kind of concepts that I learned in November of 1991 have absolutely governed my ability to be a trial lawyer for the last 34 years.
Yeah, I mean, in my experience, I went to the big firm, and I was one of the lucky ones because I got to be second chair on a fairly big case early in my career because the junior partner went on maternity leave, and the senior partner was like, kid seems fine. I don't need anybody else. I mean, it was just kind of like, it wasn't like there was no plan. It was just, I got thrown in to do depositions 6 months in, but without any other training other than having watched him do the first five, then he let me do the next five, you
Right.
know, and I would have loved, but then never sniffed a courtroom other than to argue motions for 6 years.
Yeah, and I mean, the difference in my world is, in 1992, I had what was at that time a very famous murder case in the Kentucky area where was interviewed by not only local news networks, CNN, because of both the facts of the case and the facts that I was able to get it dismissed on Edwards grounds. And so that's what I was doing when most people were still trying to figure out the way out of the library. And that was great for me. It was what I needed. That began kind of that step of developing confidence in my abilities, and confidence in my reasoning that I think I probably wouldn't have developed otherwise. And when we've hired people, I know I'm jumping ahead, but it goes together. My litigation partner, who unfortunately is leaving at the end of this week, for the last 10 and a half years, had when he came to me, he was licensed in Kentucky but not in Indiana. And so I said, "Well, I really like you. I think you'll be great. But why don't you go work at a public defender's office for a year while you're studying for the Indiana bar?" And I can guarantee you he had the exact same result that I did. When he got to me, he was ready to go. He was ready to try cases. When your life for those years is, you're in the courtroom from 8 a.m. to 4 p.m., and then you're in a jail from 4 p.m. to 7 p.m., then you get up the next morning and you do the same thing, and you're handling 250 or 300 cases. There's not a lot someone's going to be able to throw at you that's going to scare you.
So you said earlier that you're not a big firm guy, and
Here
yet
we
the
go.
most you did was spent, what, 15 years in a big
15
firm?
years.
Yeah. So
You're gonna
what
love this story, though,
I'm ready.
as to how I got there. Um, Again, I was, the public defender in 4 small counties in Kentucky. There was a Commonwealth's attorney, whose name was Kim Snell. He was absolutely fantastic lawyer. His wife was Virginia Snell, who, interestingly enough, was the hiring partner at Wyatt Tarrant and Combs. And so I've never been convinced that, either Virginia thought I was going to be a great hire to be over here in the Indiana office, or if Kim just wanted to get rid of me and didn't have to deal with this pesky young public defender who seemed to think he was smarter than everybody else and was not afraid to go try anything. So that's how I ended up at Wyatt. And I ended up over here in New Albany, where I am right now, as a contract slash associate in the Indiana office. And so it was still like not completely being thrown in, kind of like Annabelle into the Cincinnati office of Dinsmore. At that point, we had probably 8 or 10 lawyers, and we're a branch office of the main firm.
What was that like being in a branch as opposed to in the middle of the action where people are making decisions?
It's difficult, and I think it was much more difficult for the partners, who were present at the firm. That office, which is no longer here, had evolved from a very, very successful, small town law firm in Southern Indiana, who really probably represented, I want to say every client, and that probably wouldn't be not too much of a lie, about 90% of the clientele in Southern Indiana. And Wyatt decided that they wanted this Indiana presence, and so they bought out that firm. So you had a group of partners who had been in complete control of their lives, who now aren't. And it was quite a struggle for them figuring out how to fit into the culture, how to satisfy the requirements that the larger firm correctly was putting on them. So there was always tension in the office. For someone as low level as I was, it wasn't as noticeable. But I will say that probably the mentorship opportunities that I might have had in the larger office were not as present in the smaller office. And that's not by any means a knock on my partners at Wyatt. It was just a reality. They were kind of trying to feel their way through the transition in the same way that I was. So, at times, it kind of felt like being on an island, because, I was hired in to do a lot of insurance work, simply because of the trial experience. They knew I could come in, you could give me 125, 150 files, and not have to bother me. And the great thing about that primary client, that I was working for at Wyatt in 1993, I'm still working for today in 2025. So, it's one of those things I look back on and go, okay, this might not have been my perfect cup of tea, but it sure to hell helped me set up where I am today. I would not have been able to make these transitions from the public defender's office to where I am today without that experience.
Was the expectation that you were going to just be able to switch to trying cases, a different kind of case?
Yes.
And how did that work out?
It worked out with me spending a lot of time learning law. Literally, I laughed when I got the hire. I remember looking up to the main lawyer in the New Albany office, and I said, "Okay, I'm ready to go. I'm going to start in 2 weeks. Give me whatever I need to know. Give me the reference points. What's the law in Indiana on this and that? I'll learn it, and I'll be ready to go." Because that's my personality. Vividly remember within a month of being there, the advice I got from the then directing partner of that office, which is, Larry, it's okay to kind of lean on your plow every now and then. Meaning that if I gave you a case and I gave you assignment, I don't need it back in 15 minutes. It's okay to take a break every now and then because I walked in, I began to handle the civil cases in the exact same fashion I'd handle the criminal cases. Because, in the criminal cases, you didn't have time. It was boom, 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 move it through, get it done, next one. And that's how I came in and started handling the civil cases. I mean, I looked at a file. I mean, my probable first thought is, okay, I assume this is going to get tried in 2 months, not 4 years from now. And I was ready to try it in 2 months. So a bit of a transition, you might say. It could have something to do with my ADHD or, we'll see.
So then from Wyatt, you went to what, MTSH, right?
At that point, it was McNeely, Stevenson, Thopey, and Harold. And that was a firm out of a small town near Indianapolis called Shelbyville. And I was familiar with kind of the two managing partners, Lee McNeely and Mike Stevenson, just from my years of working. Lee also worked for the same major client that I worked. So we had kind of a natural relationship that was already built in. I mean, it was a really tough decision to leave Wyatt. Not because I loved it, but because, we all get in this, and I'm trying to choose my words wisely here.
Let
We
me
all
let me
get
see
in
if
this
I
near.
let me see if I can make a suggestion. When I left Lewis and Roca, the senior of seniorist partners said, "Be careful of fur-lined ruts." And I said, "What in the world are you talking about, John?" And he said, "It's very easy to get in a rut that's comfortable. So you may not."
That's exactly right. Especially with my background. If you come from a lower middle class upbringing, you come out of a small school, you don't really have either familial or friend mentors, to kind of walk you along the way. When I'm there at Wyatt, for those 15 years, making what today is laughable, but I thought was a great salary, and I had health insurance and I enjoyed the people who were around me. You then begin to question whether or not you can do anything else. And it's probably the biggest lesson I've tried to give not only to my younger lawyers and my partners here, but to any other younger lawyer that I meet, which is develop that confidence in yourself because I didn't have it. If I'd have had it, I would have left far before I did. Not because Wyatt was a bad place. It wasn't. It was a great place. But I needed to have that confidence that I could step into a role and make a success for myself and kind of form a firm or an office in the visage of what I would want it to be. And, it's funny. I mean, I tell people you were talking about the rut. For me, it was kind of, it's okay to dread going to work on Sunday. That's natural. But when you're kind of dreading going to the office on Friday after you've just left the office, that might mean it's time to make a change. And I think mine for me was as much psychological as it was anything else. And luckily, Lee and Mike were there. I left with one other partner from Wyatt who had been at Ice Miller prior to coming to Wyatt. All he knew was big firm life. He was 62 at that point, but someone that I cared about and was like, I'm going to leave. Why don't you come with me and let's see what happens? So we opened up a 2-person office in 2009. At that point, the plan was in my head Probably, you know, we're going to continue doing this kind of work, and that's what my life is going to be like. And as we're soon going to talk about, boy, did that change just a little bit over the following 16 years.
So at some point, then let's go back to where you're a two-person office with a mothership up near Indianapolis. How did that compare to being a satellite office at a big, big firm?
Sure, good question. We had complete autonomy. I was allowed by Lee and Mike to run the office how I wanted to run it, to begin the process slowly of, I guess, when I look back on it now, starting the building blocks to the next step to the future. And what I mean by that was we began to get involved in the community at a much higher rate. I mean, that's one of the sometimes drawbacks of the bigger firms is because they have over 50, 60, 70, 80, 90 years develop their book of business, they might not be as good as they need to be about getting into the community. And not only getting into the community, because everyone's willing to write a check and say, look what we sponsored, but actually do things. You know, I always say we don't write checks unless we're going to be there. We don't join a board unless we're probably going to run it at some point. And that transition began. And so it was almost like a franchise, might be the best way for me to say it. MSTH was looking to do something in the South because, again, they're up in central Indiana. So it was a good fit for us. But we very quickly began to kind of formulate an individual office plan within a firm. Does that make sense? Yeah. Yeah. It wasn't that we were being told, you must do X. I mean, truly, the only requirement was make money for yourself and make money for us. And if we were doing that, then it was going to work. And it did work for over 10 years.
So you made the decision to make the switch to having your own firm. And when did that happen?
That happened. I'll give you two. I'll give you a temporal landmark, and then I will give you the exact date. It happened about 6 weeks after I had a knee replacement, which is kind of the way I remember it. But it happened at the end of 2019. We opened up CLLB in 2020. The kind of important thing, though, to keep in mind is I mentioned we started at two. Then my partner who came over with me, Rich Beerley, retired. I had a fella that had worked for me at Wyatt, Steve Langdon, who was at Frost Brown. Steve joined me at McNeely Stevenson in June 2009. We then added a family law lawyer, Dana Eberly, who's now one of our partners here at CLLB. We then hired my litigation partner. And then in around 2017, 2018, we added two more lawyers. So you can already see that the original plan for this office has been thrown out the window. And now we are looking for the future. And now we are making decisions solely based upon what's going to happen in 10 years, what's going to happen in 15 years. We're not making any decisions for today or tomorrow. And we hired Jason Lopp and Gary Banet. Jason and Gary both came from, well, were the remnants of Wyatt's New Albany office. Gary is a very high-end estate probate lawyer, probably at this point the best known and most respected estate lawyer in Southern Indiana. And Jason is probably the best banking and commercial lawyer in both Southern Indiana and Louisville. And we were able to bring them on. Once Jason and Gary got here, and then we had the core of the four current name partners, and we had a core of good associates, the plan was, all right, we think we can do this on our own. And that led to the eventual decision at the end of 2019, buy out our old partners and form CLLB.
Excellent. So you opened CLLB in January of 2020. What challenges did you face making this transition just before the COVID-19?
I'm going to say, boy, let's think what happened in 2020 that was loads and loads of fun. Probably the biggest transition for, or the biggest challenge for us is we officially made this decision in November of 2019 and had 6 to 8 weeks to get a firm up and going, meaning all of the administrative, all of the technological, all of the ethical requirements with four guys, while at least most of us are pretty business oriented, had never run a business like this before. And we're starting from scratch. I mean, it was literally 18, 20-hour days at a minimum in just the planning to get us up and going. I laugh as we're doing this Thanksgiving week. I remember going and doing the 5 a.m. Black Friday shopping because we always get wreaths at Home Depot for Christmas decorations, and then coming straight to the office at 6 a.m. And at 6 a.m. till probably 2 or 3 o'clock that day, my partners and I were meeting, kind of finalizing budgets, finalizing lines of credit with local banks, and finalizing the steps to get us up and going by January 1. That was the hardest part, was we did it in such a short framework.
Excellent. And did you run into any hurdles in March of 2020 when the pandemic really kicked off? How did that change your plan?
Believe it or not, we didn't. The funny thing about it is, because of the timing of opening up, we had upgraded all the technologies. We had we had new websites, we had new IT people, and we were uniquely positioned to make the next step. The biggest one, I vividly remember, we're in the middle of March, and if you probably look back into the annals of YouTube, and might maybe still on our website, I did a video about how to do remote mediations because we were ready to do it. We had Zoom before most people had Zoom. We had the technology. And so, as stupid as it sounds, I remember standing in our front lobby with one of my secretaries in a conference room and one of my partners in his office, and visually showing the audience, here's how a remote mediation will work, and here I am ready to do it for you. So for us, it was great timing. The challenge, of course, had to do with, how do we, or do we, keep the office running live, or do we go remote? We had several of our associates at that time who had young children. And so obviously we gave them the opportunity to work primarily from home. Now, the 4 partners at that point, we all came in every day. I didn't miss a day. The way our office is set up, there was always enough distance between people that we didn't worry about it. Now, I laugh and say that we offered all of the staff the chance to work remote, and I swear the answer was, we're all married and we'd like to remain married, so we're going to come to the office. Which amused the absolute living life out of me. So again, it was hard. It was scary. You always wonder, as a step off, are we going to be able to continue, especially in the estate area? And then Steve Langdon does an unbelievable amount of elder law, Medicare planning, end of life planning. And we had great concerns whether or not we could continue those relationships, whether or not that generation of people would be willing to do meetings by Zoom or to do meetings by phone call, or whether there was just going to be, just this valley of time and money that was going to be a problem. Luckily for us, which has kind of been our history since we've done this, it wasn't, and we survived.
And when you were building the firm and deciding what it was going to be, why did you make the decision to structure your firm without a singular managing partner?
That is a great question. And that's something that we have discussed over the last 5 years continually. At different times within this 5 years, we've discussed whether it's time for us to make the transition to having a managing partner, or even to having an office manager. Because we don't have an office manager. I mean, the now 6 partners run the office and run the firm. We had lots of discussion about, what's the name of the law firm going to be? What's the administrative structure going to be? Part of my personality is, I'm not one of those guys into, how do I want to say this nicely, self-promotion, or into advertising myself as a lawyer. I mean, if you came into my office, I don't have my diplomas up. I love being a lawyer, absolutely love it. But is it the number one thing that I describe myself as? No, probably not. And I was the oldest, of the 4. And so there was always the discussion of, well, should we call this the church law firm? What should we do with it? And to me, it was always a collaborative effort. I could not have started this law firm by myself. I could not have led this law firm to being a success without not only my named partners, but our associates and our support staff. And my thought was, all right, we need to have a name, or at least an acronym, that's very easy to remember and kind of floats off your tongue. And so the interesting thing is, CLLB not only is Church Langdon Lopp Banet, it's actually in the order of our age, in the order of our experience, and it's the only combination of those 4 letters that makes any sense. I mean, LCBB, BCLL, that makes no sense. CLLB, rolls from your mouth. And one of our local judges, actually the fellow whose office used to be where I am sitting right now, coined it club law, and that has sort of stuck with some people. And so they either incorrectly call it club law or they hit the CLLB. The whole managing partner idea was, again, we wanted it to be collaborative. For a lot of firms and a lot of offices, that would never work. We are four very, very different people with very, very different political beliefs, with very, very distinct opinions on everything. But for whatever reason, at the end of the day, the four of us have, for this amount of years, been able to come up with the right decision. Now, that doesn't mean we don't have spirited discussions, nasty emails, angry texts that will flow between us. But at the end of the day, this collaborative process has worked for us. Can I tell you it will work in the future when others join the four? I can't tell you that. My gut is that within the next 3 to 5 years, we will either have a managing partner or we'll have an office manager that runs most of the day to day. Because the kind of complicating factor for us, and I think I mentioned this earlier, is we own our buildings as well. We own buildings here in New Albany. We own buildings in Salem. So we have a separate real estate company as well, that there's an identity of interest between the named partners of the law firm and then the members of PSR Realty, which creates kind of a great synergy between the two companies, but also then creates, kind of an unbreakable tie for the four of us because we manage tenants, both personal tenants and corporate tenants. I look out this window here and we have a huge parking lot behind us that, often is the absolute bane of my existence, worrying about, the insurance on that, the liability on that. So, when we made this decision to come to CLLB, it wasn't just, hey, let's form a law firm. It was, hey, let's form a small business that includes a law firm. That was a very long-winded answer to your question.
How do you keep from one partner of the four of you always having to do the administrative stuff? Because
We
sometimes,
literally have our own lanes.
yeah,
And the phrase that they get so tired, and I won't use the exact phrase that I utilize because it probably has a word in it that I shouldn't include in a podcast, but it's stay in your lane. Um, like we have one of the four of us that's in charge of operations for the law firm and the real estate company. There's two of us that are in charge of finance and administrative stuff. We have one that's in charge of technological stuff. I can't speak for the other three. I can tell you how I handle those things. If it ain't in my lane, I ain't reading the email. And if it's something that we need to discuss, we discuss it and we make a decision in that fashion. I mean, there is not one overbearing personality. I mean, I run the meetings again because that's just, yeah, you know me well enough to know, yeah, he's got a little bit of a control thing. So I tend to run, our partners meetings and our equity partner meetings, but there is no decision that's not made amongst the four of us.
Excellent. So you've mentioned a lot of collaboration on the leadership level. How would you describe your firm's culture in general?
We try very hard to make this a place that you want to come to. We don't have billable hour requirements for either the partners or the associates. We tell everyone that we are interviewing, that we are hiring, that we have several goals for you. One, and this is a goal that people never believe, but it is the God's truth, because it's what I have told every person I have hired, from my partners to my associates. My goal for you is to make more money than I make. I want to put you in a position where you can do that. The best example I can give you of that is I mentioned Steve Langdon earlier. Steve, when he came from Frost Brown Todd, believed he was going to bring a large corporation defense, a casino, and be able to handle that work. He went out to Vegas shortly after joining us to meet with them, and as he likes to say, as he was entering Caesars, there were people, about 30 people carrying boxes, leaving Caesars. So everyone with whom he had a relationship was now gone. And so, needless to say, there was no work. And we didn't panic. He was like, oh, we'll figure it out. We'll figure it out. And within 6 months, he had an opportunity to begin to learn elder law and had an opportunity through a client. And I remember him coming into my office going, is this something that you want me to do? Is this something that you think will be good for the firm? And I remember having the conversation, and he and I kind of came to the same conclusion, and that conclusion has carried through to today, is we will do whatever we can do to make you a success. If that means you need X amount of dollars to market, you got it. If that means X amount of dollars to learn, to go to CLEs, to join the right organizations, we'll do it. Anything that we can do to help you get to the position you want to be in, we're going to do it. Now, does that mean we're perfect? Absolutely not. We have lots and lots of faults, but one fault we will never have is that we're not going to support our associates and our partners in whatever they need. I told them one goal, make more money than I make. What's your requirements? Work hard, be a good lawyer, be someone people want to be around, be involved in the community. That one for us is absolutely non-negotiable. You must be involved in boards. You must go through, the local leadership groups. People must know who you are and be happy that you're a part of the community. I mean, it's as simple as for the last 10 years, we have sponsored the Friday night summer concert series here in New Albany. And it's because it's right across the street from the office, and I'm not an idiot. It was a chance to be out, be talking to people. It's amazing how more interested people are to talk to a lawyer when he or she is in shorts and a t-shirt and has a drink in their hand. They're a lot more comfortable talking to us. That's the culture we have tried to develop. Like I said, we're not perfect by any means, but we try really hard to be collaborative on everything that we are doing and to be supportive of everyone who works for us. And I know that sounds like, crap, but that is really who we are. And again, people don't believe it till they're here. A simple example, I'll give you one more simple example, then I'll shut up. Every single person from whoever believes themselves to be the lowest on the totem pole to whoever believes themselves to be at the top of the totem pole gets bonuses every year, and throughout the year. They get Christmas bonus. We try very hard to have quarterly events. One of our associates is related to a family that owns a glass blowing business. So the entire firm went and made Christmas ornaments on a Friday afternoon because that's the thing to do. If you don't like the people you work with and you can't work with them, you're not going to be successful. And so we learned a long time ago that the success of CLLB and the success of the individual lawyers really has little to do with the members of CLLB. It has to do with the people who are here and the culture around us. Another long-winded answer. I apologize.
Have you ever had anyone take advantage of that open and transparent culture?
Duh.
What did you do about it?
Well, it happens. If that person or those people just maybe weren't the long-term fit. I mean, you got a couple choices in life. And I was talking to a buddy of mine about this not too long ago because I've always tried to put other people in front of me because, again, I know that any success I have is determinative by other people. And like I said, you get slapped in the face sometimes. And then you've got to decide, well, what's the right answer? Do I continue being that person or do I become the person that I don't want to be and just be solely concerned with myself? And the little mantra I've given to people for 30, as I said, I have never looked in the mirror and just saw myself. And I don't expect you to do that either. I expect when you look in the mirror, you see your loved ones, you see your family around you, you see your community, you see your partners. And if you can look in the mirror and honestly give me the answer, that's who you see, we're probably a really good fit for you for a place to work.
I mean, yeah, the what a great genius can accomplish by themselves is not very much.
Not much. Not much.
Conscious of your time and the fact that you have a firm to not run a piece of. So I'm going to skip a little bit ahead in the outline. Primarily what you do day to day now is serve as a mediator. Is that right?
Correct. I mediate, any place between 6 to 10 times a week, handling cases primarily in Kentucky and Indiana. I mean, occasionally I get pulled into cases around the country. Probably have mediated, I don't know, 3,500, 4,000 cases in my career.
How did you make the transition from being primarily a litigator to primarily a mediator? How did you decide?
I was certified as a mediator back in probably 2005 because I was interested in it. As I mentioned earlier, I like solving problems. I like working the logic through to try to make a better resolution to an issue. Part of that motivation is probably because I take the counselor part of our job as seriously as I take the lawyer part of the job. But when we went through COVID and had that transition, it seemed like the right time to jump in full speed. I'd been doing the actual trial work for 25 to 30 years at that point and felt like I had the knowledge that I could be helpful. So I decided, let's give this a shot and see if it works. And lucky for me, apparently I do a decent job of mediating cases. I try to treat people when I'm mediating the way I would hope others would want to be treated.
Think about how did you first decide to become a mediator? How did that happen?
Sure. As I was mentioning earlier, when I was at Wyatt, I had the opportunity to take the week-long mediation training, and that was probably in someplace in like 2003, 2004, 2005. I took that primarily not only with the plan of potentially becoming a mediator at some point, to learn how to be better at mediation. Because after the early 90s, every case in Indiana was required to go to mediation before you could even get a trial date. And then that began to swim across to Kentucky, and it's pretty much the way over there as we move forward. I was so busy during that time period that, I really didn't have the time to step in. And plus, I was, not as old as I am today. And so perhaps they think gray hair helps. When you're mediating. But I always had really enjoyed it. It's kind of the ability to combine being a lawyer with being a counselor. Your goal is to try to find a solution, not really decide who's wrong or who's right, but to figure out a way to help people or help corporations put this horrible event that has kind of stalled out their lives away. Maybe not make them all happy, but make them happier than they were when they walked in the door. So for me, it is an absolute joy. My friends say I am only happy when I'm either mediating or at the gym. And if I could mediate at the gym, I would be happier than I could be at any point in my life.
So when you're doing a lot of these mediations, you've got outside counsel, the client. How often is the client corporate counsel?
I would say on the defense side, probably at least a third of the time, unless it's a kind of non-corporate type case, then I'm rarely dealing with the actual people or all of the actual people. If it's a corporate dissolution or a law firm dissolution or a state matter or like a contract matter, then I have all of the real people, as I like to say. If it, however, is an injury claim, which is probably, 80% of what all mediations are, then I have the plaintiff and sometimes his or her family along with their lawyer. And in the defense room, I have a defense lawyer, and then I have a representative of either the insurance company or the corporate entity instead of the actual alleged tortfeasor.
Do you insist to have the person with authority to settle the class?
Yes.
The case be in?
Yes. And I am not a nice person when that doesn't happen. And I also insist that people be prepared. The little story I can tell you about that, and it's slightly inappropriate, which I'm sure you're not shocked by. But the first time I went to the National Academy of Distinguished Neutrals annual conference, they wanted to shoot some videos of some of the newer members. And they had a course of like 5 or 6 questions of what they were going to interview you about and video it. And one of them, of course, was, how would you describe your style as a mediator? So I thought long and hard, and I had a great answer that I wasn't allowed to use on the video. And my great answer was, I'm a prepared asshole, meaning when I go in to mediate a case, I view it as if I'm trying both sides of the case. I will know the case backwards and forwards. I will have typically 5 to 6 to 7 pages of my own notes, which often will include issues that pop out to me, as well as questions that I expect the lawyers and or the client to be able to answer. Now, the hardest part when you're mediating, especially when you're dealing with an individual, is one, getting trust from them. The way I try to get trust is I open up every session with a plaintiff in the exact same way. Tell me about yourself. And they often get confused and start instantly telling me about the dispute or telling me about their injury or telling me about whatever they think they're here to tell me about. And I'm like, no, that's not what I asked you. I said, who are you? And they go, well, why are you asking me that? And I said, well, the dirty little secret is for you as a plaintiff to do well, if this case ever would go in front of a jury, you've got to make the jury care about you. And the only way they're going to care about you is to know who you are. And I follow up by saying, we lawyers, we train to ask questions. We think we're really, really good at asking questions. And we're the worst people in the world at asking questions because we will only ask you a question that A, we want to know the answer to, and B, that we think is going to help our case. We don't learn anything about the individuals. And as soon as I am able to make that one-on-one personal connection with the plaintiff, my job is already about halfway done. The advantage I think I have over a lot of mediators, and I tell people this all the time, I have lived in every socioeconomic class that there is. I can connect with someone who is from the poorest or the smallest county in Indiana, or I can connect to the corporate person who is here to argue about a $50 million contract. Because I probably have something in common with all of those people. And I don't take myself real seriously. I tell people I use humor in every single thing that I do, simply to make people more comfortable. Like right now, I'm in running shoes. I have a live mediation this afternoon. I am not changing out of these running shoes when I'm mediating the case because I need them to be comfortable with me and comfortable with the process.
How do you deal with it when one side of the mediation is taking a ridiculous position?
I hold the mirror and let them know it's a ridiculous position. I tell them they have absolute every right to have that position. The kind of little, I always call them Larry-isms. I say you can come with whatever number or whatever position you want when we sit down together, but you damn well better be able to back it up. If you can't support your argument, if you can't support your evaluation of the case, you are probably not going to have a good time in our hours together. I think you and I may have spoken on the phone. I had a long mediation a few weeks ago that was very complicated and very emotional and very difficult, as I had lawyers from all around the country who were being forced to listen to this poor, dumb Indiana hick mediator who was trying to tell them what to do. And at the end of the case, we got it settled. But I can guarantee you I'm probably on some no-fly lists at the present time because there were a few people who probably were in positions of power that will not be sending me a Christmas card and would love to see me getting held up in an airport.
But I think the best mediators I've seen have a tenacity toward getting something done.
It's results. I tell people, you have really kind of three basic types of mediators. You have the number carriers, people who just walk from room to room saying, well, I won 100,000. Well, I got 5 and go back and forth and get nothing accomplished. You have a second type of mediators.
I used to love the ping pong mediators.
Oh my God. Ping pong
Because
mediations make me want to jump out a window.
Oh, I know. I would drive the mediators crazy because I remember once the mediator, I was in London. I wasn't living there at the time, and the mediator declared an impasse. And I said, well, that's fine, but I got to fly back to the States tomorrow. I won't be back. This is their last chance. Can we just get the parties together so we can leave on a good note? And the mediator's like, oh, okay. And what I realized is that the number that I had was, which I wasn't to yet, and the mediator couldn't get me to use all my authority because I wasn't gonna until we were close. So we came back in and I made this speech about how I came here for this. I'm going back. I won't be back. This is your chance. And one of them turns to his lawyer and says, can't we just go back to playing ping pong?
Well, absolutely.
And we got it done 3 hours later.
No, I mean, it's fascinating. I mean, because the third type of mediator, which is the one I think I am, is I am result-oriented, and I am result-oriented early. My sole goal is to help you reach a resolution and to try to dispel every negative thought you have and figure out a way to get there. And a lot of times, I've kind of got a reputation that I'm hard on lawyers, and I say I'm sure that's true to a point. But I said I'm really hard on mediators. And I'm hard on mediators for the fact that I see too many that will give up too easily
Yeah.
and don't think outside the box.
And
I
the
mean,
ping pong mediators for sure.
Yeah.
I've had mediations last, 45 minutes.
it does just come down to figuring out the big picture. I again tell people I'm not a weeds guy because weeds don't help us to get to a result. There will be things we have to argue about. There'll be things we have to discuss. But at the end of the day, the question is, do you want to resolve this case or not? And to get there, you have to figure out, as I often ask, what is really going on here? What's your real motivation? Are we involved in this estate thing because, your brother spilled ink on your sofa when he came over at Thanksgiving, so I now hate him? And that's the reason that this $5 million estate can't close because he ruined my couch. Sometimes that's the motivation. Sometimes the motivation is, well, this is about justice. This is about right or wrong. I tell every single plaintiff, you'll never hear me say right or wrong, fair or unfair, or absolutely when I mediate. And I tell them those first 4 words have nothing to do with our system. And absolutely, I cannot absolutely tell you what any jury is going to do with your case. I can give you really good advice, and I don't expect you to follow it. I expect you to have a conversation with me about why I think what I think. When I go into a mediation, you're never going to hear me just say something off the cuff. I'm going to give you what I honestly believe. I'm very blunt. I know you're shocked. I tell people I play blackjack, not poker, for a very specific reason. I don't have a poker face. I can't put one on, but I will work like hell to get your case settled. And if I don't get it settled at the mediation, I'm going to keep working like hell to get it settled before you have to go to trial. I'm sorry, Annabelle, I interrupted you.
No, that's okay. My question was, how has your experience as a mediator changed the way you approach more of your leadership roles?
It's changed everything because it's confirmation that there are no actual wrong answers. There just may be wrong approaches. And what I mean by that is I can't go in to a leadership meeting with my concept of what Larry thinks is right and what Larry thinks we're going to do. It's no different than when Neil was talking about earlier. You have one side come into a mediation and they have a ridiculous position. It's no different than when I go into a partners meeting and I want X just because I want X. I want this to occur just because I want it to occur. I have to be able to sit down and try to work through the problems. The funny thing, I guess it's funny, I've been referred to as dad here forever. When there's a problem, let's go to dad. Dad'll figure it out, and it's because I think they know that I am able to remove myself from the question and remove myself from the dispute and give you my honest feeling as to what the right answer is. And so mediation has made me, I think, a much better partner and a much better leader within the firm because it just points out, hey, dummy, you're not always right. And so maybe you need to see the other side of the picture.
And do you have any advice for law students who might be interested in mediation?
Absolutely. Go to as many mediations as you can. Don't listen to someone who tells you this is how you do mediation. I cannot mediate the same way as anyone else. What works for me in a mediation would not work for you because we're not the same person. And what would work for you would not work for me. To be an effective mediator, one, you got to be prepared. You got to know the case. Absolutely have to know the case. If you're not prepared, please don't be a mediator because you're going to cause more problems than you're ever going to solve. Second, to me, the absolute most important characteristic of a mediator is he or she must be a chameleon. You must walk into a room or log into a room, analyze the room, and figure out what that room needs. Do they need just a sounding board? Do they need someone who just is going to listen to their story? Do they need affirmation? Do they need, that's really horrible. I'm sorry that you've been through this. How can we try to make it better? Do they need an awakening? Hey, dummy, this incident wasn't that person's fault. It was your fault. And here's why it was your fault. Or do they just need resolution? And each of those possibilities changes the way that I walk into the room. Especially in the corporate rooms. There are times I have to have a very controlling, very didactic approach in the room because that's what that individual understands. If I go down, Larry's land of comparisons and happy conversations, that's not going to work for that person. That person needs to be down like, okay, Neil, I understand you say A, B, and C. I respect that. Let me explain to you why D, E, and F are things you have to consider as well. And those times we walk through those exact facts where the other, 85% of the times, if I tried to do that in the room, they would already have clicked off. Or they would have put in those invisible AirPods that I, talk to you that I put in usually when Neil talks. So it is all of those situations of just analyzing your surroundings and figuring out the right answer. Does that make sense?
Absolutely.
What do you do with the trial lawyer who wants to make this his opportunity to try the case?
I'll let him try it to me once, not twice. I'm infamous for saying, I got it. I understand. I hear your argument, but let's talk about the other side. Or what's your goal here today? Is your goal here today to look really smart in front of your client? Is your goal here today to make them give you the best Google review ever? Oh, this guy was fantastic at mediation. Or is your goal to get your case settled for your client? And, if it's either of the first two things and not the third, then we have to work through why it's not the third. I mean, I told a lawyer whom you all would know if I mentioned his name, which I will not do. In the third hour of mediation last week, I literally looked away from him, looked to his client, and said, this is your case, not his. And so you and I need to be talking. And you and I need to decide whether or not the advice you're getting is the right one or whether you should settle it. And the way I typically convey that when I'm not as irritated as I was that day is I will say, you need to listen to your attorney with two ears. Just give me one every now and then so we can chat about it. Because there is sometimes a canyon in between the client and the lawyer. And that's on both sides of the room. I mean, there are times where the goal of the lawyer is not necessarily the same goal as the client. And that is not making a negative opinion about any lawyer. It's just he or
I
she.
certainly had lawyers trying to, when I was corporate counsel appearing with my trial attorney, who was never going to get to try the case, obviously, and I knew that. They may not have. They were always trying to, not all of them, but more than you would think, were trying to win the mediation, to show me how great they were and I could let them try this case, to show the other side how dumb they were and why they had absolutely no hope. And it didn't do anything toward promoting resolution. I'm not sure, sometimes it would just harden positions. And so I went from the very first mediations I ever went to as, associate general counsel who didn't know the cases that well because I'd been dumped into it. I would definitely sit there like a bump on a log, let the trial attorney take the whole thing. It probably wasn't 10 mediations into my career before I realized that I'm the client, I'm going to be front and center.
That's exactly right. I mean, I am rather infamous, especially in defense rooms, of I will let the lawyer talk at the beginning because, usually he or she has sent me a submission. And I always say, if you're dumb enough to log into one of my Zooms, you're probably going to have to answer some questions. And by the time I go in the room the second time, it would not be the only time I've ever done this, which is covering up the lawyer and just saying, hey, let me talk to Annabelle. Let me talk to the client here. Let's work through this. And some lawyers get a little offended. Most lawyers who I deal with on a regular basis know, hey, Larry's just talking to the guy who has money, and she's going to make the decision. And it really is her decision, not the lawyer's decision. So let her talk.
I'm going to let her talk now.
Thank God.
You mentioned you were kind of ahead of the curve with Zoom and those sorts of things prior to the pandemic. So would you say that was the most significant way that technology has changed your practice?
I would say it's definitely changed the world, both in mediations, but also, and that's a positive way. The negative way I would say that it's changed the world is prior to COVID, you would go to every pretrial. You would go to every motion hearing. And you got to know the lawyers, and you got to know the judges, and you got to know the court staff. And you learn the lay of the land much quicker and much better because any of us can prepare ourselves for a hearing. And we can make that 5 or 10-minute argument in front of the judge. But if you've never met the judge in person, if you've never met her assistant or her court reporter, you don't know who to reach out to if you're having a problem. If you've never physically met the opposing counsel because everything you've done is on Zoom, you have no relationship with that counsel and you're going to have great difficulty solving problems. So while technology has made it much easier for us to multitask and not waste 2 hours, driving to some county for a 5-minute hearing, you've lost that connection. And that's something that worries me about the younger lawyers, because then when they actually do have to go try something or do have to go and actually be in front of the judge, they're not in the same position I was because of the fact that we got to have that FaceTime and we got to work together and try to figure out the solutions. So I kind of see it as both a positive and a negative moving forward. It's positive for efficiency. It's great for me in mediation that I actually have, as Neil asked earlier, typically someone with complete settlement authority on Zoom because they don't have to fly up from San Antonio or DC or wherever. The relationships just aren't the same. And like I said, that concerns me. The fact that every case now has to go to mediation is great for my bottom line, but it's probably not great for the practice. The old days, I could pick up the phone or walk down the street and get a case settled. A hell of a lot easier than it can be done today. And that was just because we had those relationships.
And how are you approaching artificial intelligence and those sorts of advances?
It's a great question. I Mentioned I went to the NADN. You can tell I like acronyms better than long names. Seminar last year in Montreal, and there's a brilliant family law mediator named Susan Guthrie, who is from Chicago. And she gave a presentation on AI and mediation. And I walked into this thinking this is going to be the dumbest thing I've ever sat through in my life. And it was unbelievably fascinating because she was talking about it from the mediator's perspective and how a mediator would be able to utilize AI. Because, we think about it and we go, we know that good percentage of lawyers are using AI to do research. We know that a good percentage of lawyers are using AI or ChatGPT to come up with potential arguments. I apologize. But for a mediator, how I see it as being positive is, especially in a really contentious or a really complicated matter, AI may give me 30 solutions where I can only mentally come up with 5 or 6. And it opens up our world. Again, is it terrifying? Absolutely, because, there are mistakes, there are hiccups, there are things you can't completely trust. But the way we left that session, and I believe it strongly, just like Zoom, just like the copy machine, just like the fax machine, mediators and lawyers who use AI will have a gigantic advantage over mediators and lawyers who do not use AI, because the world, it is a-changing, and we're not going to go backwards. And the little surface of AI that we're scratching today, in 10 years, will look as ridiculous as a flip phone. And so if we're not prepared and not willing to try to figure out how to integrate it within our practice ethically, we're missing that step. It's a challenge for an old guy like me, let me guarantee you.
If you got it.
I think that's all I have.
That's all you got? Okay. Let me ask the question that I probably knew the answer to 34 years ago if I'd been listening instead of just rambling on endlessly. When you look back at, 1L, 2L Larry, what were you worried about that you look back at and go, gosh, I wish I hadn't spent so much time thinking or worrying about that?
I couldn't do it. That it was beyond me, that I wasn't smart enough or that I wasn't equipped enough. The big one probably was that I had never run a business, that I couldn't run a business, that I just didn't have the capacity to make it work. And again, that's what caused that stagnation for all those years. And stagnation is a bad word because it's too negatively connotated. But the rut, as you used it, if I would have known that this was possible, I would have done it much earlier. And again, I tell all of my lawyers, I say, I just don't want you to get stuck the way I did. And Annabelle, you're kind of in that perfect situation. You're going to a great firm, wonderful firm, where you're going to have endless opportunities. But realizing the fact that that first opportunity isn't your only opportunity is critical. And that doesn't mean outside of your current firm, it means within your current firm as well. And just having your eyes open and being willing to say, hell yeah, I think I can do this. And just take the chance and have the belief and confidence in yourself. Because if you do that, you're going to succeed. It may not be the way you set out to succeed, but you will absolutely succeed.
Can't think of a better way to end it. Thank you
All
so
right,
much.
my friend. It's great to see you. Annabelle, wonderful to meet you. You guys have a wonderful Thanksgiving.
All righty. Thank you.
All right, ciao.
Ciao. All right. We're not recording now, but you don't have to stop talking.